Welcome to the debate. Today, we are immersing ourselves in the historical evolution of a legal mechanism that, well, it sits right at the intersection of civil law and social justice. We are looking at the Motor Vehicles Act, specifically focusing on the concept of no-fault liability and how it actually applies to road accidents.
Yeah, it is a genuinely fascinating topic because this mechanism is fundamentally rooted in the ideals of a welfare state. It is really about how a society chooses to protect its citizens when, sudden tragedy strikes on the road.
Exactly. And for our lay audience, let us briefly break down what no-fault liability actually means in plain English. In traditional law, proving fault is the absolute requirement, the golden ticket, if you will, to getting damages. You have to prove that someone did something wrong or was explicitly negligent.
Right, which, as we know, can take years of litigation.
Right, years. But no-fault liability flips that script entirely. It dictates that a victim or their grieving family can receive compensation even if the driver or the vehicle owner took reasonable care. Even if they were absolutely, demonstrably not at fault, the liability is undeniable.
It is a strict liability. It's designed to provide immediate relief. But the core of our disagreement today centers on the historical evolution of this law. Specifically, we are looking at the 1994 legislative amendment, which introduced Section 163A and its structured mathematical formula.
The central question being, did this 1994 amendment perfect the welfare state's goal of swift, guaranteed justice? Or did it introduce rigid mathematical constraints that ultimately hindered fair compensation when compared to the dual benefit system that existed before 1994?
Exactly.
I will be arguing that the 1994 amendment was a necessary and highly beneficial evolution. It replaced meager interim payments with a rational, substantial, and fast-tracked compensation formula.
And I will be arguing that while the pre-1994 system certainly had implementation flaws, the 1994 amendment introduced rigid, exclusionary income caps. These caps quickly became completely outdated, forcing vulnerable victims into a deeply unfair legal trade-off.
To truly understand the magnitude of the 1994 amendment, we have to look at the foundational philosophy of compensation. Justice Krishna Iyer famously noted that when we value human life in a free country, our compensation laws need to be generous, not stingy.
I completely agree with that underlying philosophy, but we differ heavily on how the law actually executed it on the ground.
Fair enough. Let us look at the landscape before 1994. The no-fault liability provision, which was governed by Section 140, was well-intentioned but severely limited. It provided only fixed interim amounts. We are talking about 50,000 rupees for a fatal accident and 25,000 rupees for permanent disablement.
True, the amounts were small, but you have to recognize the primary, indispensable benefit of that pre-1994 system. Under that older framework, the no-fault liability provision was explicitly designed as interim relief.
Meaning it was meant to be a stopgap.
Exactly. A victim could claim that immediate no-fault financial aid to handle emergencies, hospital bills, or funeral costs. And then, and this is the crucial part, they were entirely free to pursue full comprehensive compensation through a fault-based claim later on under Section 166.
So they got a quick payout up front and then fought for the rest.
Right. They could get immediate help and still fight for their full rightful damages based on the actual loss of earnings and compensation for the loss of a spouse's companionship. It was a dual benefit system.
I maintain that Section 140 was a vital first step, heavily motivated by the constitutional directive of providing social justice. It was engineered to give immediate financial relief without victims bearing the heavy, often impossible burden of proof right out of the gate.
But the theoretical framework is precisely where the success of Section 140 ended. In practice, the objective of immediate relief was completely defeated by the systemic delays inherent in the motor accidents claims tribunals.
The delays were certainly a recognized issue.
They were crippling. The data on this is incredibly stark. If we look at the empirical studies conducted on the implementation of the law during that era, the reality on the ground was a complete failure of the legislative intent. The government had actually issued instructions that no-fault liability applications should be disposed of within 45 days.
45 days is an incredibly ambitious turnaround for a legal tribunal.
And they didn't even come close. In a documented study of 20 no-fault liability cases from that era, not a single one was settled in less than 6 months. 14 of those cases took more than 12 months to decide, or dragged on for more than 2 years.
That is a staggering timeline for emergency funds.
One was still pending after 3 years and 10 months. When an interim emergency payment takes almost 4 years to process, it ceases to be immediate relief. The dual benefit system you praise was a mirage because the first step was trapped in the same bureaucratic quicksand as the final fault-based claim.
To ensure we are evaluating the mechanisms of the law accurately, could you elaborate on the nature of these delays? Looking at the data, were these extensive delays a fundamental flaw in the statutory framework of the law itself, or were they primarily an administrative failure within the tribunal system regarding how the dockets were managed?
That is the pivotal question. The delay was a toxic combination of both, but the statute itself lacked teeth. The Motor Vehicles Act did not prescribe a mandatory punitive time limit for disposing of these claims. The statute merely stated that claims should be disposed of as expeditiously as possible.
Which, in the legal world, is a fairly ambiguous directive.
In the realm of statutory interpretation, as expeditiously as possible is an open invitation for indefinite delay. The tribunals were essentially applying the rigorous evidentiary mindset of a standard civil court to a provision that was supposed to be summary and immediate. The law provided a theoretical right without a structurally enforced fast-track procedure.
I see why you think that, but let me give you a different perspective on how the legislature responded to that exact crisis. This brings us directly to the genius of the 1994 amendment.
I wouldn't use the word genius.
Hear me out. The legislature recognized that the procedural gridlock was destroying the welfare objective, so they enacted Section 163A to fundamentally bypass the entire evidentiary quagmire. Think of the 1994 amendment as a fast pass in an amusement park. It got you to the front of the line for a payout, bypassing the grueling legal wait times.
But you had to accept a highly structured, sometimes smaller ride.
Yes, by introducing a predetermined, mathematically rational formula detailed in the second schedule, they removed the discretion and the lengthy arguments over quantum from the tribunals entirely. It allowed a final, substantial payout without a lengthy trial over negligence.
But let's clarify how that math actually worked.
It used a multiplier method. It calculated compensation based strictly on age and income. A younger victim with a steady income would trigger a higher multiplier than an older victim, logically reflecting their remaining earning years. This meant an aggrieved family could walk into a tribunal, establish the basic facts of the accident, apply the formula, and walk out with up to 537,000 rupees.
In theory,
it transformed a subjective, dragged-out legal battle into an objective administrative calculation. In the context of a developing nation with an overburdened judiciary, replacing discretion with a structured formula was a masterstroke of systematic efficiency.
I'm sorry, but I just don't buy that. Let me tell you why that mathematical efficiency was actually an illusion of justice.
An illusion? That's a strong word for a guaranteed $500,000 rupee payout.
It is an illusion because that fast pass had a massive catch. The government basically built a fast lane for compensation, but they put a strict height restriction on the entrance. The second schedule, which provided this mathematical multiplier, was explicitly limited to individuals with a maximum annual income of 40,000 rupees.
That was the cap set by the legislature, yes.
Now, think about the economic reality of that. The Supreme Court, in the landmark 3-judge bench decision of Depal Girishbhai Soni versus United India Insurance Company, definitively affirmed that only individuals earning up to 40,000 rupees per year could avail themselves of the benefits of Section 163A.
Because it was a targeted welfare measure.
But if you earned 40,001 rupees, you were entirely excluded from this supposedly fast, rational welfare mechanism. And here is where the height restriction analogy really bites. As inflation surged through the late 1990s and into the 2000s, the daily minimum wage for unskilled labor in many states quickly exceeded this cap.
Inflation did outpace the statutory numbers faster than anticipated.
Exactly. 40,000 rupees a year is roughly 109 rupees a day. The very working class citizens, the daily wage earners that this welfare law was designed to protect, were systematically priced out of its protection by mere inflation. They kept hitting their heads on the doorframe.
And therefore had to rely on the traditional fault-based system.
Yes, they were forced right back into the grueling, delayed process of Section 166, having to prove fault against well-funded insurance companies. And remember the dual benefit we talked about earlier? The 1994 amendment stripped that away. If you chose the speed of the new formula, you were legally barred from filing a fault-based claim later. You had to forfeit your right to full restitution.
That's an interesting point, though. I would frame it differently. I would frame the income cap not as an exclusionary trap, but as a deliberately targeted social security scheme.
Targeted at a demographic that essentially vanished due to inflation?
The legislative intent was specifically to grant expedited relief to a specified vulnerable section of society whose income was heavily limited. It was an acknowledgement that those at the very bottom of the economic ladder are the least equipped to sustain a prolonged legal battle over fault.
But my point is that the bottom of the ladder moved up and the law didn't move with it.
That is fair, but you cannot look at the statute in a vacuum without looking at how the judiciary interacted with it. The formula was not entirely unyielding. The courts continuously adapted it to fit economic realities when the legislature was slow to act.
Judicial intervention isn't a feature of a good law. It's a symptom of a bad one.
I disagree. It shows a living legal system. A perfect example of this is the Supreme Court's pragmatic approach in the case of Kasangapal versus Lala.
I am familiar with the case.
For the audience, the second schedule originally prescribed a notional income of 15,000 rupees per year for non-earning persons, like children or stay-at-home spouses. In the Kasangapal case, the court realized that saying a stay-at-home parent is only worth 15,000 rupees a year was absurd in the modern economy.
So they changed the math?
Yes, they actively considered the falling value of the rupee. Recognizing that the original figure was obsolete, the court effectively doubled it from the bench, increasing the notional income to 30,000 rupees just to make the math fair and reasonable. The system demonstrated an inherent flexibility.
That's a compelling argument, but have you considered that relying on the Supreme Court to perform judicial band-aids actually proves my point? It proves the 1994 legislative amendment was structurally flawed from its inception.
How does a court fixing a problem prove the law itself was a failure?
Because it is a failure of legislative design if a mathematical formula meant to provide immediate automated relief at the tribunal level requires the highest court in the land to constantly intervene and rewrite the numbers just to make it barely functional.
The wheels of legislation turn slowly. The courts simply stepped in to maintain the welfare objective.
But even with those judicial interventions, the systemic failure became so undeniable that the legislature ultimately had to throw its hands up and abandon the structured formula altogether. If the 1994 amendment was such a triumph, we wouldn't have needed the radical overhaul of recent years.
You are referring to the recent repeals.
Exactly. First, the Ministry of Road Transportation and Highways had to issue the 2018 notification. That notification scrapped the complex age and income-based multiplier calculations for fatal accidents entirely. They replaced it with a flat, fixed amount of 5 lakh rupees, irrespective of age or income.
Which simplified the process even further.
And then came the ultimate concession of defeat, the 2019 amendment to the Motor Vehicles Act, which introduced the new Section 164. This new section completely did away with Section 163A and its second schedule.
It replaced the old formula with a new mechanism.
We have essentially returned to the pre-1994 philosophy, but with modern numbers. The law now provides a fixed sum of 5 lakh rupees for death and 2.5 lakh rupees for grievous hurt on a strict liability basis. It totally discarded the multiplier method that was the hallmark of the 1994 experiment. The fact that the entire structured formula had to be legally eradicated proves that attempting to quantify human life through a rigid table was a well-intentioned policy disaster.
I'm not convinced by that line of reasoning, because the evolution of a law does not negate the value of its previous iterations.
I think an outright repeal heavily implies it wasn't working.
Not necessarily. The progression to the modern 2019 framework was only made possible because the 1994 amendment shifted the entire legal paradigm first. Before 1994, compensation for motor accidents was fundamentally tethered to the law of torts. It was always about finding a villain to blame.
True, the fault-based mindset was deeply entrenched.
The 1994 amendment, despite the eventual obsolescence of its specific math, successfully mainstreamed the doctrine of strict liability in Indian motor vehicle law. It proved to the system, to the insurance companies, and to the tribunals that they could handle substantial, final payouts without the necessity of establishing negligence.
I acknowledge it shifted the culture.
Exactly. Without the experimental stepping stone of Section 163A, the legislature would never have had the empirical data or the jurisprudential confidence to enact the sweeping, fixed-sum guarantees of the modern Section 164. We must judge the 1994 amendment by the landscape it inherited, not just the landscape it eventually gave way to.
And what did it inherit?
It inherited a broken system offering 50,000 rupees of heavily delayed interim relief, and it replaced it with a structured path to a $500,000 rupees of final settlement.
It is absolutely true that the 1994 amendment shifted the paradigm, but we must be incredibly critical of the human cost of that shift.
The cost being the income cap exclusions you mentioned.
Yes, and the forfeiture of rights. When you replace a system that allows victims to claim both immediate relief and eventual full restitution with a system that forces them to choose one or the other, you are commodifying justice.
It was a choice offered to the victim, though. A fast track or a thorough track.
But the 1994 amendment forced families into a desperate gamble at the absolute worst moment of their lives. Do you take a lesser, capped amount now because you need to pay for a funeral? Or do you risk years of litigation for what you actually deserve to replace a lifetime of lost earnings?
It's a harsh reality of legal settlements.
The doctrine of strict liability is indeed essential, but the 1994 iteration serves as a vital cautionary tale. It demonstrates with absolute clarity how rigid statutory formulas, when combined with inflexible income caps, can inadvertently defeat the very purpose of a welfare state.
Because it failed to account for economic growth.
Precisely. A welfare state must protect its citizens from the unpredictability of both accidents and inflation. When the law freezes compensation metrics in time while the economy moves forward, the law ceases to provide welfare and begins to provide mere bureaucracy.
As we draw this intricate discussion to a close, it is essential to synthesize our perspectives. My position remains that the 1994 amendment was a monumental and necessary legislative leap.
A leap that eventually had to be walked back.
Modified, I would say. It modernized the concept of no-fault liability from a mere interim stopgap into a robust, structured path to compensation. By providing a mathematical formula, it allowed countless victims to bypass the deeply traumatic and legally torturous process of proving negligence against powerful insurance companies.
For those who could fit under the income cap.
Even if the number is eventually required updating by the courts or the legislature, the structural shift toward guaranteed substantial payouts was a massive victory for social justice.
And my summary is that while the underlying theory of no-fault liability is an absolutely vital tool for social equity, the specific execution of the 1994 amendment was deeply flawed.
Because of the rigid structure.
Yes, it stands as a stark reminder that legislative shortcuts often create long-term inequities. By forcing victims to forfeit their right to full fault-based claims under Section 166, and by implementing an income cap that was quickly rendered absurd by inflation, the structured formula inadvertently excluded the very working-class victims it was intended to serve.
And you see the 2019 changes as the ultimate proof of that?
I do. The fact that the system had to be entirely rewritten in 2019 to return to fixed, universal amounts proves that rigid, complex formulas are fundamentally incompatible with the dynamic realities of economic life and human tragedy.
Yet, despite our robust disagreement on the efficacy of the 1994 mechanism, we converge on a profound and essential truth.
Which is?
Both of our perspectives highlight that the core principle of no-fault liability, is an unshakable, fundamental pillar of modern civil law. The belief that victims of sudden, catastrophic road accidents deserve swift, guaranteed compassion and financial relief regardless of technical fault.
I completely agree with that convergence. The philosophical shift away from the strict strictures of traditional tort law, where every accident requires a villain, toward a system of collective social responsibility is one of the most important developments in jurisprudence.
It's an acknowledgement that the mechanization of our roads comes with a human cost, and society must bear some of that burden.
Exactly. The debate is merely over the optimal machinery to deliver that justice, not the necessity of the justice itself.
Precisely. The evolution of these motor vehicle laws, from the basic interim reliefs of the 1980s to the structured formulas of the 1990s, and now to the modernized fixed sums of today, shows a legal system that is constantly striving, and sometimes struggling, to balance cold mathematical formulas with complex human realities.
It is a constant work in progress.
The material we have examined today also opens the door to so many other crucial aspects of this legal framework. There is much more to explore regarding the complex dynamics of third-party insurance, the doctrine of pay and recover, and the specific operational challenges within the motor accidents claims tribunals.
We've really only scratched the surface of how tribunals handle these tragic cases day to day.
We encourage everyone listening to dive deeper into these legal structures. We will leave the ultimate judgment on the legacy and impact of the 1994 amendment to you, the listener. Thank you for joining us for this rigorous intellectual exchange.